in order to get to the funding aspect, and a commitment was made that we would address governance first and then funding second. And what we're doing here today is really kicking off what I hope is a second chapter of a reassemblage of the coalition of the willing on this issue, including some significant organizations, to start working on a permanent, what I hope is a permanent funding solution. The vehicle for that, currently anyway, is a constitutional amendment that I and others introduced along with accompanying statutory changes late in the session, after the end of the general session this year. That by no means should be an indicator of that's what we're going to do or that's what we should do. It is, just from my personal perspective, merely a starting point. I think it's a good starting point, frankly. We had to start somewhere, right, as the saying goes, and it seemed like a good place to start. To me, and as I've expressed to others, and then I'll be quiet, this issue is a balance. We do not have a bottomless pit of resources, especially in this recessionary economy. By the same token, we have constitutional responsibilities, and the question is, how do we best strike that balance? It strikes me, at least at the outset from 30,000 feet, that having a permanent funding resource, i.e. the fees that the system is already generating, which I think currently are somewhere around in the low 42 million, something like that, it's a good. I think it's positive to have a floor, so that the system knows and the system can prepare for around a certain amount of money. Which is not to say the system is going to generate $42 million every year. It's not going to. We know that. But by the same token, it doesn't preclude the General Assembly, as we do with everything else, from an additional appropriation based on a demonstrated need, quantified empirically, as solid as a rock, as agencies come and make their annual pleas, like any other agency. So that's the vision, if that could be described as, that I had on this particular issue. But again, if there's a better way, I'm going to ask folks in the room who have worked on this issue to this point to come together as a group and help achieve a consensus on it, so that we can have something, we can have a truly positive, credible, realistic alternative to look at. And it may be this legislative package that we've put in. It may not be. Whatever it is, I think our best work, and I think folks from both sides of the aisle would agree, I think our best work always happens during the off year, in the interim, when it's relatively quiet, current political circumstances notwithstanding. But generally in the off year, it's a good time for folks to get together and to work out issues and to use the luxury of time that we have. And I intend to do that from my perch. So what I've done, and I think in order to expedite this process, what I've asked, just for the folks who have been here, Representative Atwood, Representative Benfield, I appreciate your being here. What I have asked certain organizations, entities to do, specifically the administration, by and through Mr. Sackerson, the Public Defender Standards Council, by and through Judge McGarity, who I understand is here. Thank you, sir. Right, strategically positioned in front of, so he can just dodge to his left, and of course Brian Cabin representing the State Bar, as well as I think Ms. Nesbitt is going to speak for the ACCG, and those are, I believe, to be very relevant players. They're people who were very involved in our effort last year. I hope that they'll be as participatory and as engaged this year. That does not preclude input from any other organization or any other entity. But again, we have to start somewhere, right? So that's where we begin. And what I'd like to do, I'm going to call on those four folks on behalf of those four entities to come forward and just, if you could, give us your vision to the extent that you can. I understand that there are no lines in the sand on this issue right now. That's not what this is for. It's for you to, if you would want to lay out a vision of where you see this issue going. If you have any idea, if you have any opinions on the legislation, on the proposed CA that's been put in, and you want to express them, please do. If you don't, you don't have to. If you think it's moronic and you've got a better solution, please let me know. You can't be effective in this job and suffer the sin of pride. It's impossible. You can't get anything done if you're too proud. So please let us know. I think it's appropriate to start with the administration. And Mr. Sackerson, if you wouldn't mind coming forward, we'd like to hear from you. Just generally, if you could give us a few minutes of sort of how things are going, and then if you could, transition into what you see as perhaps the positives and the negatives of the proposed CA. What are we missing? No one's asking you or the administration to commit to anything. But if you have a vision for a better solution or solutions, we're all ears. So I'll just please take the floor, and then if you would, we'll have questions from members if they have any questions, and we'll just march on from there. And again, we'll shoot for 2:30 and see how aspirational that is or not.
All right. Thank you, and good afternoon. I'm Travis Sackerson. I'm the director of the Georgia Public Defender Standards Council. Want to thank you, first of all, for having us. Most importantly, regardless of the direction we end up, I want to thank you for being interested in the issue and working so hard with us and this particular cause, the indigent defense funding for indigent defense, and then last year, of course, Chairman Golick's bill as far as trying to make the system work in the way that the legislature and the governor felt best. As the chairman said, the bill, House Bill 648, and the House resolution, the constitutional amendment that accompanies it, changes the language for funding mechanisms that already exist. What this is there are 4 or 5 different fees and fines that create the indigent defense fund, colloquially. That's what's referred to a lot of times. And what this is, if you go through by section, it looks at, and I believe it's sections 1, 2, 3, 4, and 5 deal with one form, and then section 6 and section 9 deal specifically with the different funds that exist that fund they're originally laid out to have a relationship to funding the program, and then what this does is it certainly firms up the language to make it dedicated, those different funds and fees and fines. So just from a dollars and cents standpoint, you understand what it is we're talking about. And last year, as the chairman alluded to, the indigent defense fund total, we're looking at about $42.5 million, I believe, is what we ended up with. It would have gone to the general fund, and then the legislature appropriated from that to our agency about $38 million. So again, at the end of the day, this last budget year, using that as an example, you're looking at a difference of about $4 million between what the funds overall would have generated and then what was provided to the agency through general revenue. The bill, the House Bill 78, I guess, was, and then the previous budget. So that's what the overall dollar and cents that you're talking about, and that's as it breaks down to what our opinion would be about each one of these specific sections of the bill. It's very clear. I mean, it doesn't make large changes to the mechanism as it's set up now. It just changes some of the language as far as dedication. And so we didn't really have any, after going through the bill and looking at it from an agency standpoint, it's very clear, and so I wouldn't necessarily have any recommendations one way or another about that part. And so the as to going forward, there are obviously some, there are issues with indigent defense, much like every agency over the last few years, with the setbacks to all of the budgets for a number of agencies. And so additional funding is not the only way to solve some of those issues, but certainly would help with a number of the issues and setbacks that the agency suffered over the last few years. So with that, if you have any questions.
Sure. And at the outset, and I appreciate the administration's full-fledged support of the proposal. Just testing. The fees that are actually being dedicated, they're being generated right now in the low 40s. In the appropriation of 38, I mean, at the outset, the response would be, well, it's only a difference of $4 million. Is that worth going through a constitutional amendment process in order to go ahead and dedicate those funds that are generally already being appropriated anyway? My sense of it is that it is a good idea because, and you by all means throw all kinds of water on it if you want to or need to, that it establishes a floor so that the agency, from an operational standpoint and from a macro adequacy standpoint, generally knows what to expect, and it doesn't preclude the General Assembly, with the approval of the governor, from appropriating more. And so under the category of what is to be lost and what is to be gained, while there's right now, at least under the current fiscal year, a difference of only $4 million, which in an $18 billion budget is percentage-wise small, very small. But doesn't it make, under the category of what is to be lost, what is to be gained, doesn't it make sense to have that floor there? I don't want to call it as a comfort zone because I think that's a little too simplistic. But it does allow for predictability for the system. It does give, on a year-to-year basis, the system the ability to quantify metrically, which way is the system going, what's generating, what's not, and so that budgeters, appropriators, and governors can plan accordingly. I don't think there's anything to lose by it. Right now, under the current rubric, there's not a whole lot to gain other than $4 million, which is not nothing.
Absolutely.
So what's the downside, if there is a downside, of having that dedication, potentially?
Well, particularly with the formulas you just laid it out, what you referred to as certainty, I would use as an example the fact that in 2010...
Well, a trend, it's not certainty because it fluctuates, but there is a trend that you can see over a multi-year basis like you do with any budget, right?
That is correct, but
Okay.
there was a difference between 2010 and 2011 of about $3 million, which is, again, a substantial amount of money that you would... It is a floor, but it is also a... There's fluctuation there as well. So I don't necessarily want to lose sight of that there will be changes over the collection of the Indigent Defense Fund, of these fees and fines. It changes every year from a high of around $45.5 million to last year about $42.5 million. So I mean, there are going to be substantial fluctuations that will also make for administrative difficulties. But you are correct. I would never disagree with the overall theory that you're laying out there. But I did want, from a brass tacks standpoint, to explain that.
Members of the committee. Ms. Benfield.
A couple of questions, and one I'm embarrassed that I don't remember because I was here then, but prior to the establishment of the new statewide indigent defense system, as I recall, the public defender's offices in each county were funded by collection of court cost fees. Is that correct?
Yes and no. I mean, for the most part, it would have been the counties individually would put a certain amount of money in. They would receive a certain amount of money from the state as well. It was much less than they receive now. But so maybe each county might have had a different funding mechanism for that. So and again, that predates me, so
Okay.
I can't say with certainty.
So somebody else who's testifying today might be able to answer, because I'm interested in how it worked before. I do remember there were some issues with collection. So I'm interested in how this would be different. One concern I have is the nexus. Clearly, where you're collecting the $50 from criminal defendants to fund the Public Defender Standards Council, that makes sense. But you're also adding $15 to civil actions. Has there been discussion about how there's not a nexus between, essentially you've got civil litigants funding the criminal system? And was there any discussion about whether or not that's fair? And was there any discussion with the trial lawyers? Did they have any concerns or issues with that?
And are you saying back in 2000 when the $15 surcharge was created? Because this doesn't create any new funding as far as there's no change.
Oh, you're right. That's not underlined. Okay.
Right.
It's just being allocated to this new dedicated fund.
Right. It's my understanding, and after going through the bill and looking at it, there's no new fees or fines or anything.
That's right. I mean, and just to make sure the intent is clear, and with all fairness to counsel and also myself, we went ahead or counsel draft this late in the session when only juggling 18,000 other things along with the rest of us. But just regardless of that, the intent here is to take the fees those fees that the system is generating now, and rather than having them go into the general fund, they'll be dedicated for the purposes for which they were originally intended pursuant to the original legislation, I guess in 2003. Is that right?
Yeah, there was, in the original act, there was actually language that sort of tied all these monies to funding indigent defense, and then a few years later there was an issue about that, and that language was removed. And so, there was, when I say there was language tying it, it was pretty language. It wasn't constitutional language. It was a suggestion that the money should go in that way. And if I could answer
Please.
Lieutenant Benfield's
Sure.
question from earlier, there was under GIDC, there was grants to counties, but the money was actually provided mostly by the counties, but there was all of the counties that had PD offices or whatever their system was could apply to GIDC for a grant that was state money, and it was was stated was substantially less money.
Oh, yeah.
I think 10 or 11, 12 million.
If I can, Mr. Chairman.
Sure.
Okay, my point is still there. The fee, the way I read this, the fee under existing law is collected, but the fee is not going towards a Public Defender Standards Council. So my concern about you're asking civil litigants to fund the criminal system where there's not a nexus between the civil and the criminal, was there any discussion about whether that's fair or not, and does that have any impact on access to the civil justice system?
Well, I did not have any discussion with anyone necessarily about that. And it frankly hasn't come up. No one has approached us to talk about that this has been a problem over the last 6-7 years that it's been in existence.
And I mean, just to close the loop on that, no one from the Trial Lawyers Association has expressed any concern to me about that, either then or now. But that doesn't preclude them from doing that in the future. But that's just as it stands as of this minute.
Thank you.
All right. Mr. Sackerson, thank you.
Oh.
Appreciate it.
Thank you.
Let me ask Judge McGarity, if you would. And Judge, you and I have not spoken. You are a member of the newly constituted Public Defender Standards Council. Is that right, sir?
That is correct.
And you're under. I wanted to make sure that you, as a member of the council, or as the representative of the council, certainly had the opportunity to provide some feedback from 30,000 feet or lower or higher as you see fit. And we were interested in your perspective on it and anything that we may have missed, or we just welcome you and look forward to working with you in the coming months.
Thank you. Let me go ahead and introduce myself. I'm Judge Arch McGarity, the Chief Judge of the Superior Court of the Flint Judicial Circuit, which consists of Henry County, just about 35 minutes south of here. I used to be a judge. I'm 16 years in judgeship, used to have a 4-county circuit, so I know what a circuit looks like when it's 4 counties. I know what a single county circuit looks like. I was in place before the whole system was changed. I got on board in 1995. I am speaking today as an appointee of the Lieutenant Governors to the Public Defender Standards Training Council, I think. I'm not sure if that name actually changed or not, but 2 years prior I was on the pre-existing council. So I spent 2 years appointed there, and now we've not had our first meeting yet, so there's been no action taken as to regard to this. When I change hats in a little bit, I will give my comments for the Council of Superior Court Judges, because I was asked to be here for that before I was asked to speak, and I'll just give
Many
you
hats.
just those two, and one's a little smaller than the other. At the outset, I would note that $4 million might not be a lot of money, but when your budget's $38 million, that's a lot more in percentage than it is to the statewide budget. And my first meeting that I attended over 2 years ago, before I became a member of the council, a good bit of it was taken up with shortfalls of money. And I don't know that I've been to a meeting since getting on the council the last 2 years that they didn't have discussions of shortfalls of money. Now, I don't know, I have my own opinion how we got there, but I'm not going to share that with you at this point. This point, I'm here for solve these bills that got dropped, the Resolution 977 and House Bill 648. My main interest as a member is that we be adequately funded. And as a person who has raised children, the child's idea of adequately funded and my idea of how adequately they're funded are two different things. Because I'm the one doling out the dough at home, they're on the receiving end. Oftentimes they didn't have enough money in their minds, but in mine they had sufficient. And so we had to have these discussions we're having now about how best to make those ends meet. And as long as they were doing their job as to where they spent the money, I felt like I had to do my job about producing the money. So here we are today trying to look for that best way to come up with funding an indigent defense system who in the system and oftentimes cannot have a fixed budget. It's very difficult to have a fixed budget because you don't know what's in store. You don't know when your next Brian Nichols case is coming down. You don't know when your next multiple murder case is coming down with a death penalty. You just simply don't know. After it was set up, the problems I saw were the judges were taken out of the loop as far as how lawyers got paid. And that was left to other people, and then some of them didn't do that. They didn't pay attention. And now I think, and Travis and I had a meeting last week, and the last year I think we've done a much better job of how the lawyers are gotten on board, especially in conflict cases. So I feel very confident that our leadership, the new council, that we're going to make the dollars go as far as they should go, but that no defendant is not properly represented by a lawyer. And that means you can't do it on 50 cents a case or $1 a case or $50 a case, but not all cases are $100,000 cases either. So we have to have some monitoring of that, and I think that's in place because of the powers that the new executive has that runs the agency. On behalf of all my history of being involved in the criminal justice system, I've been a lawyer since 1977, and I've had my share of appointed cases under the old system. And I think that the most important thing is that it be whatever funding source we do, that the taxpayers are confident that they're not going to vote for a constitutional amendment that they perceive is going to step into their wallet with new taxes of any kind.
This does not do.
I understand that, and that's why I'm
just to make sure it's
language is important.
Crystal clear for all.
When I see that certain existing fees and assessments scare me because all homeowners have assessments in their homeowners in their subdivision, and sometimes they're out of the blue expensive assessments. The wording could possibly be to existing user fees,
sure,
and criminal fine surtaxes, so that those I'm not a criminal and I'm not using it, so I don't have to pay for it. That's another side. If it gets past that, always will have to be tweaked as we go down the road. Great when you can't read your own handwriting, but not important. It wasn't. If it was, I'd be clear on it. As far as the dedicated funding, I am under the impression that there are at least 13, 14 maybe agencies or portions of agencies' funds are dedicated that come from, like the spinal injury trust fund, all of those things that come from these type of assessments and or surcharges. The thought that occurred to me was that maybe there's some hybrid that would work for everybody, where the money is dedicated, and I think the not lapsing is very important, as the governors have always had a rainy day fund that was substantial at one time. It's substantially lower now, and that one of those could be built up over time, hopefully, so that when we have those unique years when maybe the revenue's down, but we have those really wild cases that cost a lot of money, we'll have something to tap into, and that there would be some methodology to tap into that through seeking guidance from the oversight committee or the budget committees or whoever y'all deem fit, but that the funds will be still there, be generated year to year. That's sort of how, as a private practicing attorney, criminal cases went for me. And I do believe 99% of all criminal lawyers would love to get on hourly payroll, would love a client who could pay them $250 an hour no matter how many hours they spend on the case. But that's just not the way it works. People come in the door, aunts, uncles, grandma, mothers, fathers, and what's it going to cost for you to represent Junior? And you got to come up and find out some information about the case. You got to come up with a fee that they can live with. Or you don't get the case, they'll go down the street and find another lawyer that maybe a few thousand less. So you then take those cases, and then sometimes that $5,000 fee only takes 10 hours. You've made some money. But sometimes that $5,000 fee takes 50 hours, and you've lost money. Well, it balances out over time. Likewise, we hope that all the fees and assessments that all come in will build up. We can have a reserve account so that if we have to tap into it for those bad times, it's the same as a lawyer. And the lawyer starts pricing. If he starts losing too many of those, he's not assessing his cases well, and he has to make a reassessment, or she does. Now, I will be glad to answer any questions. I'm not sure I've said anything that's helpful. I don't know. I don't have a script here. I am interested, if we do put it to the voters, that it be put to the voters in a way that they can understand very clearly that this is not a tax increase on you. And if I could put anything in it that say you will not have to pay extra taxes, user fees would connote that, and surcharges and criminal fines would connote that. But the actual mechanism of 648, I think, is pretty clear. I think that's pretty clear.
It'll. I mean, if it should go that far,
Right.
It'll be crystal clear that it's the usage of existing monies that are already being generated by the system, and there's no new revenue. That's not the intent then, now, and it never will be.
The public defenders don't have a huge constituency that's going to vote for unlimited funding.
Sure.
I just don't know anybody out there that's going to come out and say, I'm voting for this because that gives them all the money they could ever want, and it's coming out of my money.
We're vaguely familiar with that as well.
Yes, I bet you are.
But by the same token, I mean, the people also, do expect us. This is really a management exercise more than anything else. And from a management standpoint, I don't believe the leadership of this House believes that it's a good use of the Attorney General's time to be running in and out of state and federal court on adequacy issues. By the same token, even if we were to go ahead and if the people were to approve the use of these existing monies for the system that it was originally intended to, it doesn't preclude anyone from suing the state anyway. So, and we're not naive to that. By the same token, we do, from a management standpoint, want to do our best to strike that balance. Questions from the committee? Ms. Neal? Oh, Ms. Medfield, sorry.
Yeah, first I just want to say the resolution's here, and it does say certain existing fees and assessments. So as the language is currently written, I think it's pretty good that would actually go on the ballot. The question I have, you talked about some of the other fees that are currently in existence, like the Spinal Injury Trust Fund, and I know there's some domestic violence money that's collected, and there have been issues in the past with those funds being accounted for and ensuring that they actually go towards the agency that they're intended for. We've even had some study committees to look at how to make that more efficient. So that's a concern I have, and I don't know, this may be a better question for Ms. Travis and Leg Counsel, but did any of those other bills creating these designated funds through filing fees have an accounting or report that's due annually to the legislature, just so that there's some agencies, so there's some check on how those funds are expended and to make sure that they are going towards a designated purpose.
I'd have to look at
Yeah.
each of the ones that are the list.
I don't know, but I can't imagine this body or the Senate approving any add-on fees that are going to go to some independent agency that doesn't have to account to the public. I just can't imagine that. But I know the almost all the fees are collected through the Georgia Superior Court Clerks Cooperative Authority, sort of the clearinghouse. So as far as collections, you might get in touch with David Williams, who's the director of that.
Mm-hmm.
He has all the information, and I'm on that council body also, and I think it's a fairly efficiently run outfit, and they've really gotten really good at collecting the money. And so thanks for the tools y'all given them.
Thank you, Judge.
Thank you.
Let me ask Brian Cabin on behalf of the State Bar.
Thank you. I would like to say, if I may, at the outset, just a couple of things. A little over a year and a half ago, I served as president of the State Bar. And as we were coming to the close of the legislature that year, Chairman Golick came to me. The Indigent Defense Program, Georgia Public Defender Standards Council, was rift, financial issues and the like. Chairman Golick came to the bar, talked to us about if we can get governance straightened out, then I will put the same energies toward funding, adequate funding. And he's been true to that pledge. And on behalf of the Indigent Defense Committee, which I chair this year, and public defenders, we appreciate that. This is what we need. I think there's going to be some issues that are going to come up, and they're going to try to go back, and we're going to talk about what happened over the last several years, and I hope we don't devolve into that too much. Because initially when it was set up, there was some governance. In 2008, when the changes were made, I think it was House Bill 1245, it took away some of that. The council didn't really have control over the director. The director didn't have any sort of governance over the CPDs and the like. And it really, I think that has helped to fuel some of the questions, the issues that have been raised over the last several years about this and containing costs and projecting costs and the like. Several things that have been said, I would ditto. I can go back and rehash. Judge McGarrity is a judge because he has shown his wisdom here as he has put these things in perspective. I'm still a practicing attorney. But I do understand and do feel this is the right direction. We must take these funds. And these funds, if I may, Representative Benefield, of course, these have been in effect since 2004. They designated these funds and said this is where we're going to get the money to do this. And as far as the accounting, the collecting, and the like, it is provided for on page 3 of House Bill 648 that the authority shall on a quarterly basis make a report and accounting of all funds collected and dispersed. I don't know if that's been done. I personally don't know because I wasn't focusing on that part of it when I was looking at the legislation. On behalf of the State Bar, we do support these efforts. We do support these bills. We want to continue the dialogue because there are some things, as have been already pointed out by the director and by Judge McGarrity, that we will need to have in this dialogue and just make sure that we're all comfortable with the language and the like. I would echo what Judge McGarrity said, that when you talk about $4 million, that's more than 10% of the current budget. That is a lot of money. And so if we have these monies that are there, they are available for our circuit public defenders. And I've had the privilege over the last couple of years through bar activities and the like to meet with several of you. You couldn't find a more dedicated group of lawyers or persons in this state than our circuit public defenders. I urge this. I think there are some issues, and I think Chairman Golick has tried to address most of these issues. A trust fund, or dedicating these funds, becoming sort of a trust fund, can be an issue. If that's the sole source is what's in here, that just these fines, fees, and the like. But and what happened, I just point out, in Florida, they set up a trust fund for the judges down there. And then it didn't generate enough money because of the prior acts and the like, and they had to deal with that issue because that's all the money they had. This bill provides that this will not be the sole source of funds. It's specifically written into this language, so the legislature has some latitude to be innovative in its funding and the like later on. I think Judge McGarity has addressed the issue of presentation to the people when we get to a constitutional amendment that the people have to approve. As he says, there aren't a whole lot of people out there that we're going to rally around a flag of money for criminal defendants, indigent defendants. And as I say, most of what I'd have to say would be ditto to what the director and Judge McGarity has said, and I will submit if there are any questions.
Yeah, I mean, I want to make sure it's clear. It doesn't fall on deaf ears. That, every 2 years, every single one of us hears from constituents about the potentially complicated wording of constitutional amendments, and we're very sensitive to that. I think we do well to, whatever it is, to make sure that it's actually in English. But there are legal requirements that go along with how something is worded. So that, again, that's a balancing act itself. We want it to be as clear as humanly possible. Number one, for purposes of comprehension, since a lot of folks, will be seeing that issue for the first time should it get that far on the ballot. And number two, to communicate quite clearly that we are not talking about any new revenue, but merely dedicating existing revenue. And that'll be said only 1 million times between now and then, if we get that far. Ms. Benfield.
I will.
Okay. Mr. Cabin, thank you.
Okay. May I just add one other
Sure.
thing, and that is that Chairman Golick worked last summer. We put together a working group that includes stakeholders in this, both from the county, Superior Court, CPDs, defense, and the like. We have a working group that very similar to the one that worked with you last year, ready, willing, and able.
Thank you. And we'll discuss that a little more at the end of this hearing. But I think that's the only way you can really achieve a solution on this thing, is for a lot of divergent but relevant groups of folks to get together and look at each other and say, okay, let's take this road.
Thank you.
All right, thank you, sir.
Chairman.
Ms. Nesbitt, are you? Thank you.
Good afternoon, Mr. Chairman. Deborah Nesbitt here, representing the Association of County Commissioners. And I want to echo what others have said about your leadership on this issue during last session and helping us and having us at the table when you worked on the governance issue.
It was inherited.
Thank you for your leadership.
It was. In the interest of full disclosure, it was an inherited issue, but it's, I appreciate it.
We appreciate the opportunity to be at the table. And we're here today to support the concept of dedicating those fees that are collected for the purpose of providing indigent defense to that actual purpose. We would even go a step further and perhaps broaden that, or broaden this bill to include all fees that are currently collected for specific purposes being dedicated to those purposes, to make it a broader, more far-reaching piece of legislation that would include all of those fees. There have been some mention of the different fees, like Joshua's Law, that fee, scrap tire fees. Any fee that's collected for a specific purpose really should go for that purpose. The other point I want to reiterate that others have brought up is that having the ability for additional money to be appropriated above and beyond what's collected with the fees is very important, because you don't ever know how much of those fees are going to be generated every year. You can project that out but sometimes that doesn't pan out. And so I do think it's very important that you have the ability for the legislature to come in and provide funding above and beyond what's collected in the fees, because there may not be adequate resources there. With that, if anybody's got any questions.
Let me ask you a question. Right now, what I would want to, I'm interested to know, and I think it would be helpful for the committee as well, just to step back a little bit. What is the greatest challenge that your members are facing locally with the system from a funding standpoint? And then what's your fear? In other words, what is the concern that you would have about us going down a particular path that would have an adverse result on your members?
Well, right now, as you know, and as everybody can see in the news, the counties are experiencing extreme budget difficulties at this point, but the caseloads are ever increasing. There are several things out there on the horizon that are going to impact that even more in the future, such as the juvenile code rewrite. I mean, there are going to be additional responsibilities placed on counties for representation while their budgets are shrinking. And so we would want to make sure that in this bill that your hands aren't tied as far as the funding mechanism. As I talked about, having the ability to appropriate additional funds. You don't want the resources to be tied just to what's collected in these add-on fees. I think that would be our biggest concern, and that there are continuing caseloads and continuing shifting of cost to the counties for these services without adequate resources through the fees and from the state.
Thank you. Members of the committee.
Clint would like to make a comment.
Sure, please introduce yourself.
Thank you, Chairman Golick, members of the committee. My name is Clint Muir. I'm the Legislative Director for the Association of County Commissioners of Georgia, and just want to build upon what Deborah has laid out as far as maybe a broader or more holistic approach to addressing the issue of dedicated fees. And as we know, based on history at the General Assembly, there's been sort of a resistance from the Governor's Office, from the General Assembly, to sort of tie the hands of state elected officials as far as how the fee money is used. And I think what we would propose is maybe not going so far as to lock it in and dedicate it without any flexibility, but to set up a constitutional framework that would allow the General Assembly to dedicate fees, but also allow them to redirect those fees, but do it in a more transparent manner. Right now, as you know, a lot of these fees are built into the budget. When the governor submits that budget to the General Assembly, the fees could have already been redirected at that point in time, so it may not be done here at the General Assembly. It could have already been done. And when members of the General Assembly vote on the budget, there's so much in that budget, it's hard to really lift up or show that, hey, this money has been redirected from this purpose to something else, and this is why. It doesn't really get discussed. So if there was a way through the Constitution to allow you all to dedicate the fee, but then if there's a need to redirect the fees, allow the General Assembly to come back, whether it's a two-thirds majority vote, whether it's a simple majority vote, but to do it so it's a sort of a standalone vote on the House and Senate floor, that there's too much fee revenue, therefore we're either going to reduce the fee or we're going to redirect some of the money. But to say to the public, this is why we're doing this, and do it in a transparent manner, I think you'd get broad public support for that. And I think when it comes to putting this out to the voters, without trying to tell the voters, hey, this is a specific fee we want to dedicate like indigent defense funds, they have a hard time understanding what's this fee for. There's a lot of confusion, I think, that could be generated just because the public doesn't know how these fees are being used. But if you're broader with them and said, we want to ask for your approval to set up a mechanism where you can be assured when you approve a fee or we approve a fee through legislation that it's going to go to the purpose that it was intended to go to. And if for some reason down the road we decide to redirect any of it, then we're going to be upfront with you about that. We're going to tell you why we're doing it. Therefore, you guys will have a say. You will know about it. You won't hear about it after the fact. I think that transparency argument would really help sell it with the voters personally. So, again, that's why we would recommend that the committee sort of take a broader view on this.
I can understand the issue you're pointing to, and I'm all for that. But I do believe, and I'd be interested in your opinion on this. I absolutely agree with it from the redirection argument, dedicating and redirecting, and then the transparency as to in demonstrating why it's redirected, which predictably can be seen, in a recessionary economy when, we have a lot of holes to fill on a yearly basis. But that being said, and being supportive of that, that will open up this issue far beyond the substance of what we're getting at right now with regard to our indigent defense system.
Right.
I mean, the breadth of it is pretty large. It would be a very broad issue, and don't you agree that? Well, do you agree that might be best in a separate piece of legislation as opposed to being attached to something like this? Or are you not suggesting that? Am I just presuming too much?
No, I think we are suggesting that this
Okay.
be rolled into that. Obviously, when you're talking about putting something on the statewide ballot, there's only so many measures that you probably want to put out there in any given year.
Right.
To do, you want to limit, obviously, the number of questions you ask the voters. And I think that what we're suggesting by creating this framework, you don't automatically sort of dedicate any fee, but you create the framework, and then the General Assembly then comes back and decides which fees fall under that framework. So after this constitutional amendment, if it were to pass by the voters, you all then, as a body, would have to come back and say, okay, one of those fees that we want to put under this requirement is indigent defense funds, or several indigent defense fund fees that go into that, and we want to put that under this requirement. And once you all have made that decision, then to redirect it at that point would require a separate piece of legislation, maybe a 2/3 majority vote. So all you would really be doing is creating the framework, and then that allows you to address not only these fees, but any other fees that we may not be even talking about today in the future. But it would allow you all to do that here without having to go back and have more referendums. I guess my fear is, where does it stop? If you're successful with just dedicating the indigent defense fees, you're going to have all these other groups that are going to come out of the woodwork and say, well, what about our fee? Our fee, we believe it should be dedicated just as much as indigent defense fees. What makes that fee more important than our fee? And you guys are going to be bombarded with requests. So
because we have serious constitutional issues that go along with this fee, whereas with others, we may not.
Right, and that would be.
I'd say that's a difference.
Sure, request, but I know that the general public, a lot of them, for whatever reason, they feel their fees are important for whatever goes to their cause. But I think that by doing it for one, then you're likely to open the door and have a lot of other requests, and they're going to point to that and say, you did it here, why don't you do it for us? I just think that if we're going to deal with this and spend the time and resources on it, let's deal with it more holistically and deal with the whole fee issue at one time instead of trying to do one at a time.
Questions from members of the committee? You look like you're about to explode.
No, I was listening to it, but if you expand it to include all of them, you might get some resistance from the governor. Not this specific governor, but if they've used these fees like they wanted to before, you better just take care of yourself and not worry about the other, because they might not want to be so generous.
The expansion can't be estimated about how this issue would be expanded, and I think it's important to maintain focus and to walk before you can run, maybe, which is not to take away from the credibility of the issue at all. But the question is, would this be the proper mechanism? That's, I think, a very open issue. Ms. Randall.
Thank you, Mr. Chairman. I'm inclined to agree with that. I think it would be more noticeable amongst other groups if it was a separate issue. But if we included it in here, it'll be just comprehensive around the issue of the fees, that it's collected, and it's truly dedicated to that cause. If you think it's going to weigh it down, do you think it'll weigh it down?
I wouldn't want to speculate on it. I just know that we've had a tough enough time with this issue.
Mm-hmm.
I'm just not sure it can get much tougher and be manageable. Which is not, again, not to take away the credibility of the entire dedicated fee, not dedicated, waiving of the dedication, a 2/3 vote. I mean, there's a serious. I think there's a lot of broad agreement on that.
I think
which fees are we talking about? Which you get
right.
into a.
But the difference here is that we've had a crash in the system before, and and I think if nothing else, that's a bigger argument. that we certainly did not see coming. And I just think in this case, we should take this opportunity to just try to avoid that in any way possible. And if not now, then when? And if when, I think it's going to draw more attention and more criticism from those other groups. Thank you, Mr. Chairman.
I don't think I see any other questions. I want to thank you both.
Thank you for your time.
This has been a lot more expeditious than I had anticipated, and thank you. I didn't want to have this to be an extended meeting. I think the charge that I'm going to give, it's not a charge, it's a request. And it's not a task, it's an ask. And it's not limited to the State Bar and to the Council and the ACCG, and of course the administration. But of course, I know the Criminal Defense Bar will have plenty to say, and rightly so, to work with those other stakeholders to the extent that that's desired, on taking a hard look at these proposals and make refinements and suggestions where those are possible, and to achieve consensus where that can be achieved. And I think it can. I want to be clear in saying, just from my own personal perspective, I don't think it's a silver bullet. I don't think there is any such thing on this issue as a silver bullet. I just think that there may be a better approach in terms of precluding or mitigating the possibility of larger systemic funding issues later if we have a floor established without tying the hands of the General Assembly to appropriate more on a fiscal year basis if it's necessary, as Judge McGarry said, and I think rightly so. We're going to have those anomaly years in any agency, including this one. But if we have some level of consistency across the board, given the constitutional issues that are involved, I think we do better in striking that management balance. It's just an opinion. Any members of the committee have not necessarily a reaction to that, but just a statement any comments from members of the committee that they may want to make? And what I'm going to, as folks are thinking about that, I'll just ask the members of that working group and any other members of the Coalition of the Willing to please start sooner rather than later, so that we can be in a position by the end of the year, if not earlier, to have maybe not a perfected product, certainly not a perfect product, but a progressed product. A product that's gone through some progress, that we can potentially have serious discussions about late in the year, early in the session, if that's the route we want to end up taking. My door is always open. This is not a one-time shot. There's no lines in the sand, and if anyone has any suggestions, comments, or anything else between now and the end of the year, you've got my number and my email address. So with that, I thank you for taking the time to be here today. We're adjourned.